Good afternoon, everyone. Welcome to this week's discussion and update on COVID-19. I'm Kathy Purdy. I'm the marketing manager at Schoeneck King. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as we can throughout today's presentation. Once the webinar has ended, if you would take a moment to complete the brief survey, we would appreciate that. Our presenters do look at your suggestions and comments for future topics, and we appreciate your input. So to get things started for this week, I'm going to hand it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. Thanks for being with us again today. We've got a full program, so let's jump right in. I'm going to get us started today with just kind of a summary of some things that we've talked about previously. It's a question that seems to be on everybody's mind, and it's vaccination and whether or not employers can mandate that employees get vaccinated. And so just to review some of the considerations here, I think this needs to be something that you would consider based on your workplace and on a case-by-case basis. There's probably no one-size-fits-all here. And when Katie Anderson speaks in a few minutes on the update on what's going on in Albany, she's going to talk about the phases and how we move forward with vaccine availability. And frankly, that's one of the drivers right now in any event. But when we get there, and if we get there in terms of having enough vaccine so that mandating it would be something that you really could consider and potentially do, here are some of the considerations that you'll need to keep in mind. First of all, the Equal Employment Opportunity Commission has issued some guidance, and that guidance really implies, I think, pretty strongly that an employer could mandate the vaccine from the EOC's perspective. That guidance makes reference to the FDA's emergency use authorization, the EUA, and because EUA is not full approval, there is a requirement in the EUA rules that people voluntarily consent to the vaccine. And so there's a suggestion there, or at least some are debating the issue of whether or not the EUA authorization would allow individuals to refuse the vaccine without respect to implications for their employment. They certainly can refuse the vaccine from a public health perspective under the EUA authorization. The EOC guidance seems to indicate that there can be employment consequences associated with a refusal of the vaccine, even if you prefer not to have it under the EUA voluntariness approval. One of the things that's in the EEOC guidance is a requirement, and this is also established by pre-existing case law, that employees can raise religious, pregnancy, or disability issues, and that they would need to be reasonably accommodated if those issues are validated. With respect to religion, not much is required in terms of documentation. It's a pretty low standard in terms of establishing a religious belief that might need accommodating. With respect to disability issues, I think it's pretty well established what would be needed to trigger that process. But what's envisioned by the EOC is a reasonable accommodation type process to say, is there a way, notwithstanding the fact that you may mandate for other employees, that you could accommodate these religious or disability concerns that have been raised by your employee? And some of the things that you might ordinarily think about in terms of possibilities for accommodations are certainly on the table here. Working from home, perhaps some modifications to the workspace, allowing somebody to work in a location where they are not going to be interacting with others and therefore the risk of transmission is low, those sorts of things. So, those are things that would need to be addressed on a case-by-case basis as they are raised by employees and dealt with and addressed depending upon the workplace, the nature of the accommodation request, the employer's circumstances. The next issue on my list, at least, is collective bargaining. And for those of you who are in unionized environments, you'll need to check your collective bargaining agreements and see what they say, whether you've got the right to implement some sort of vaccine mandate, or whether that's a subject that has not yet been addressed between the parties. If it has not yet been addressed between the parties, that's likely a mandatory subject to bargaining and could be bargained, potentially bargained to impasse, and ultimately, there could be a resolution on that front, either through bargaining or implementation at impasse. Even if you do have the right to implement under your collective bargaining agreement, there could be an impact bargaining demand as well from the union. And so you'll need to keep those sorts of things on your radar if you're thinking about a vaccination mandate. In a non-unionized setting, it's possible that we might see some protected concerted activity. You certainly can have that in a unionized setting too, although it's going to be much more regulated by your collective bargaining agreement and the rights and obligations that have been negotiated there. But some workplaces, there may be a group of employees that band together to say, we don't want to receive a vaccine, and you'll have to navigate protected concerted activity issues to the extent that that occurs. That would be conduct that's regulated under the National Labor Relations Act. Non-union employees do have the right to band together for mutual aid and protection. And so that's something to think about if you see that kind of activity. There are also human resources considerations. We're talking about, can we? But I suppose the other question that everyone will need to ask is, should we? And that's where I think the HR considerations come in. Is this something that is going to create a lot of issues in your workplace? Perhaps there's a better way to navigate it. Perhaps you can sidestep an emotional issue. These are the sorts of things that you'll want to be thinking about if you get to a mandate type decision. And finally, safety concerns. And I think about that. Employees may raise safety concerns if people are not vaccinated. The population that interacts in your workplace could have safety issues if your employees are not vaccinated. So this is, a healthcare setting or a residential care setting, perhaps school settings. We've got issues that are implicated there that would also influence your decision as you consider this. So those are some of the mandate considerations. I'd like to turn now to some of the practical considerations. Obviously, we've got vaccine availability. Right now, we're in most workplaces far, far away from being able to mandate because we don't have enough vaccine to deliver it. Some of the other practical considerations, the impact of refusal on the employee. What I'm thinking of here is what level of disciplinary consequences are we talking about? Leave without pay, working from home, perhaps a modified schedule that allows the person to work safely. There are things that you might think about doing that fall short of the ultimate employment action, termination, that could help you manage your workforce going forward and also minimize your legal risk and minimize the impact on the employee. Other considerations that I think a lot of our clients have in mind are, how are we going to staff our workplace? What are we going to do? With respect to our staffing. Kathy, could you just run back to the other slide real quick? I'm sorry. And then that's got people thinking about education, educating their workforce, or perhaps creating incentives rather than forcing or mandating the vaccine. Perhaps you can encourage people, convince people that it's the better thing to do. And then we've talked a little bit about accommodations, working from home. So finally, and now Kathy, if you can move to the next slide, some other things just to keep in mind. I've mentioned availability. We'll have to see what happens as we progress here in terms of availability. There are some special considerations for healthcare employers. Obviously, they're both an employer and a provider. And so, to the extent that you're a provider, you've got some additional obligations in terms of making sure that you're administering it to the right people and in a timely fashion. The governor's issued some pronouncements on that in the form of executive orders. There are the records of vaccination and related issues. Frankly, to the extent that you use a third-party vendor for those vaccinations, those issues are going to be a lot less critical to the employer. If the employer is somehow able or planning on administering it themselves, then we've got issues with respect to the information, the questionnaires prior to the administration of the vaccination. You'll need to talk through that with your attorney. Final observation for me on this is that, time may take some of these things away from us. As the vaccine rolls out, and as we begin to approach, what hopefully at some point is herd immunity, there may not be a need to mandate. And perhaps over time, some of these things may naturally take care of themselves. Right now, I think it's not yet ripe because we don't have enough vaccine where you could mandate. And perhaps by the time we get to that point, you won't need to. So stay tuned on that. But I just wanted to summarize that for folks because we've been getting a lot of questions. Okay, we're going to turn now to Katie. She's got sort of the other side of the vaccination coin, as well as a number of additional observations from this week in the Capitol. Katie, take it away.
As always, a very busy week from the Albany area. Let's start first looking at where the cases are in New York. As you can see, cases continue to climb. Positive cases continue to climb. We are now up to about, I believe it's 12 was the last I saw, confirmed cases of this new, more, intensive strain of COVID. That may be leading to this spike that's occurring in New York, but over the weekend, we did see a slight drop-off of COVID cases around the state. Is that a result of the weekend, people not being tested as much, or is that a result of an actual drop-off? Those are questions that remain to be seen and remain to have answers. We will, have a better idea next week on that. But the most pressing breaking news really comes from the governor today. This is we tried really hard to get this slide up for you so that you could see what the newest eligible phases and eligible New Yorkers are to receive the vaccine. I'm going to, when I'm done speaking, pop a link in the chat where you will be able to access the New York State website that contains this list of people. But most importantly, this happened at 11:30 today. The governor expanded the eligibility criteria for people to include people who are 65 and older. This aligns New York with the CDC's updated policies that were released, I believe, last night or early this morning, to say that people who are 65 and older should be receiving the vaccine as well. So as of today, a person who is 65 and older may receive a COVID vaccine in New York. Additionally, this will open up the category to immunocompromised individuals. The state is currently looking into what diseases, what underlying conditions would qualify a person who is immunocompromised to receive the vaccine. So it's an open question. It's one that they are consulting with the CDC on. I expect we will have further guidance on it, maybe even by the end of today, but hopefully by the end of this week. So that is a big change. My grandmother, who is almost 90, was vaccinated yesterday in Long Island. So for me, I'm very excited, but I know that lots of people are going to be very excited to have this vaccination occurring, where you're starting to see people that receiving this vaccine. It is definitely a sense of relief that is associated with it. Turning then to the state of the state. I alluded to this last week in my presentation last week, but the state of the state is a very big deal in New York. It is where the governor lays out his proposals that will go into, or likely to go into, the budget for this upcoming year. Why that matters is the governor holds a lot of sway over the budgetary process. And it began yesterday, the state of the state, and it continued today. It was a 30-minute presentation today. It will continue, it looks like, for the rest of the week. But there were 7 main agenda items. The first one, defeating COVID, vaccinations, short-term economic crises, that is trying to deal with the looking at evictions, all of those issues that are associated with COVID that we've seen that aren't related to reopening. The next one is reopening. Then we're looking beyond COVID at this point. Green energy transition, addressing the long-term impacts of COVID and capitalizing on those changes, and addressing systematic injustices. So those 7 themes are what is permeating the state of the state. There have been very sparse details given thus far as to the specific policy proposals. The biggest ones being, first, the state is going to create the Public Health Corps, which will be the equivalent or something thereof equal to AmeriCorps, where they will hire 1,000 people who will be focusing in the next year on vaccinating people throughout the state. It's unclear if the Public Health Corps will continue after COVID is done, but it is something that the vaccine rollout has been slow, so hopefully this will speed it along. Additionally, the governor spoke at length today about setting up rapid testing sites throughout New York to help businesses reopen, pointing to the Buffalo Bills game on Saturday, where people received rapid tests before they were admitted into the stadium as the blueprint to follow. It remains to be seen how that is going to be done. Rent and mortgage relief. The governor wants to codify the commercial eviction moratorium in the budget, but it will only last until May 1st. And also wishes to codify the executive order that exists, allowing tenants to use their security deposit as immediate payment for late rent. Those are big changes. Then those are the COVID changes. Next, we're turning to non-COVID changes, expanding the network of childcare options. The state wants to issue grants to create childcare programs in childcare deserts. Additionally, the governor spoke about this proposal today, the expansion of internet access and lowering the cost of high-speed internet, examining the telehealth legislation that is supposed to encourage and modernize the use of telehealth. It will also relate to insurance premiums of telehealth, but again, we haven't seen any specific proposal. And finally, the 2 most buzzy ones that we've seen in a lot of news articles about the state of the state: legalizing adult use recreational cannabis. The governor estimates that it will create about 60,000 new jobs in New York. And online sports betting. The online sports betting the way that they are trying to set it up to work is that the New York State Gaming Commission will issue an RFP, which is a request for proposals, and they will select one or more providers to offer mobile sports betting. We don't know which casinos will be chosen or if any will, but we will be watching. Finally, my final slide. The state Senate passed a rash of election reform packages yesterday. Those are all about speeding up absentee ballot counting, authorizing absentee ballot drop boxes permanently, prohibiting voiding absentee ballots based on technicalities where the intent of the voter is clear, implementing a tracking system for absentee ballots, and then finally, a constitutional amendment which would allow for no excuse absentee voting. None of these have passed the assembly yet. I expect that they will. The governor has signaled that he would be willing to sign them. One thing to note about the constitutional amendment, it would require a vote of the people of the state of New York. It would have to go on the ballot and be voted on in the next election. So that is what's happening in New York. Hopefully, we will always continue to stay on top of it for you.
Thank you, Katie. A lot going on again. That list is really amazing. and I guess is the theory that we're just going to open it up so there's always more people eligible than there are vaccines?
Part of it is, and I spoke about this last week a little bit, but whenever you open up a vial of this vaccine, it's for multiple people. It's multiple doses in that vial. And you have to use up that vial in a short period of time. It's usually 6 hours. So if you have a group of 20 people that are scheduled to be vaccinated, they're all 75 and older, for example, and 2 of them don't show up, what do you do with the remaining 2 doses? You have to be calling people who are on the waiting list to come in and get those doses. And other states are allowing people who are just walking around on the streets. Basically, if you're in the right place at the right time, you can go in and get that vaccine if you're lucky. But New York has not followed suit. So instead, New York is opening up the vaccine categories so that there are more, second string people to receive the vaccine. And I am right now putting that link in the chat with all of those.
Great,
categories.
Thank you. Okay, let's turn to Jen. We've periodically done litigation updates, just kind of check in on what's going on from a litigation perspective related to COVID. And so Jen, please take it away.
Thanks so much, Pete. Thanks for inviting me back. It's good to be with everybody. I thought I'd spend a little bit of time talking about something that's very important in the litigation world related to COVID, which is the statute of limitations. Now, for anyone wondering what in the world that is, I'm going to tell you, and I think you'll follow me quite quickly here. So a statute of limitations is just simply the time period within which you are required to bring a lawsuit after an event has happened. So I have a couple examples that most of you are likely familiar with. A breach of contract action, whether the contract is in writing or an oral contract, a lawsuit related to that must be brought within 6 years after the alleged breach has occurred. Versus a negligence claim, which would be someone who might fall on your premises at the office, a visitor, or an automobile accident. A lawsuit related to that must be filed within 3 years of that event happening. A medical malpractice action must be brought within 2.5 years of the event happening. And wrongful death has to be brought within 2 years of an event happening. Now, I could go on and talk about all of the different years. Also, the criminal code has corresponding limitations periods, but I think everyone's getting what I'm saying. So why is this relevant in the litigation world relating to COVID? Well, back in March, the governor passed an executive order 202.8, and he suspended the statute of limitations applicable to civil actions. And I'll spare you reading the entirety of the language, which I do have here, but that's kind of boring. But suffice it to say that there was a suspension of the tolling of the statute of limitations initially through April 19th. That was then through subsequent executive orders extended essentially on a monthly basis all the way through until November 4th. And at that point, there was an affirmative executive order 202.72 that said that the tolling is hereby no longer in effect as of November 4th, 2020. So, because lawyers, as we do, always can come up with different interpretations of what that means, here we now find ourselves arguing in the legal community about what did that really mean? Is it a toll in the traditional sense, which means that you have a date that, let's say you had a case that the limitations period would have been up on April 1st. A traditional toll would say you have the period from April 1st to November 4th, and you essentially add that time back on to your ability to bring a claim. Some, however, have suggested that it was really just a suspension There was no extension, and every claim that fell within the limitations period between March, when the executive order was passed, to November 4th, or November 3rd rather, would need to be filed on November 4th. There was no corresponding guidance that accompanied the executive order to clarify that. And because we're all living in real time with COVID, it was unclear what the interpretation really was intended to be. And so when that happens, lawyers, as I'm sure most of you watching know, kind of fill in the gaps of what they think that the answer should be, and make their best recommendations. There has been decisions on both sides of this. Some courts have said, and legal commentators, that it should be a traditional toll, which would, of course, advantage people who are trying to file a lawsuit. On the other side of that, people who might have a lawsuit brought against them have taken the position that, no, your claim was due on November 4th, and here we are in January, and too bad, so sad for you. So what has happened to seek further clarification, and this picks up on Katie's mention that the governor would be putting together a budget that kind of sets forth, not only we think of budget in a traditional financial way, but the budget also does a lot of things for statutes and laws that have been passed to add clarification. And so to remedy this, there has been, the New York State Bar Association has put together several task forces. I think last time I was with you, I mentioned I'm on one of them, and I know through that work, there was a group that was assembled by the Bar Association to really evaluate this issue and make a recommendation to the governor that a statute should be codified to clarify, was it a suspension, was it a traditional toll, and to really be concrete on that. Because of course, it may seem to some of you that this is a little esoteric, but it can be really important, because if you have missed that limitations period, it has significant impact on your claim, because the limitations period set forth the ability for a court to have jurisdiction over a matter. And it would be considered essentially a complete defense or a stripping of the court from the ability to even consider the claim if the limitations period has expired. And so it is quite an important issue. I know that the governor, I think, is hoping to get some insight from these groups and make a clarification. There also is a recommendation to also include in the legislation that anyone who was counseling, so attorneys or parties who were participating pro se, if they were operating in good faith, that they genuinely thought that their claim had not yet expired, that the court would be able to give consideration to that fact, so that they would not be out without the ability to proceed. And I think we've all taken, this unprecedented time. I think it's certainly fair to bear that in mind when people are relying on their good faith, or even representation by counsel who was believing in good faith, that they understood what was intended by that language, that we would want those people to be able to proceed. So it's that is a pause, and I guess we'll see what happens with the budget. But I think that there likely is clarification. It's just unknown where that's going to settle out at this point. But we will certainly, I'm sure, the firm will be sending out information once that clarification is made in the language. So with that, Pete, I'll turn it back over to you.
Thanks, Jen. Good information, good stuff to keep in mind. We're going to turn now to Aaron Pierce. Aaron is an amateur guitarist. Maybe I should say a pro, but
not a pro.
More importantly, he's an employee benefits lawyer, and he's going to talk to us a little bit about some of the employee benefit changes in the COVID relief legislation.
Great, thanks, Pete. So the legislation, the appropriations bill that was signed right at the end of 2020 included a handful of employee benefit related provisions, some of which are extensions of other relief or earlier relief that was provided either by the CARES Act that was passed in March last year or agency guidance. But wanted to run through these for you quickly. Just to note, we will be doing a more in-depth look at these changes during a webinar that we'll be conducting on January 27th, so Wednesday at noon. And you should see an announcement of that coming out within the next day or two. So just run through these relatively quickly. The first one was relief from partial plan termination rules. So there is a rule for retirement plans that provides that if you have a significant reduction in the number of active participants in a plan as a result of employer-initiated terminations, then it can require that affected individuals be fully vested in their benefit regardless of their years of service. That obviously created issues for lots of employers who have had to furlough employees as a result of the pandemic. As a result of that, the IRS has issued some limited relief. Under that relief, a retirement plan will be deemed not to have had a partial termination if they had no greater than a 20% reduction in their active participants in the plan from March of 2020 through the end of March 2021. So it's a one-time exception to the rules that otherwise apply. Although it is helpful for some employers, it probably comes as too little too late for many employers who may already have determined prior to the enactment of the statute that they in fact incurred a partial termination as a result of the normal rules and have provided for full vesting for their participants. But for those employers who have not declared that yet, then it will give them some relief if they fall within that threshold. Interesting, one of the things the Act, we kind of expected the Act to do that it didn't do was it did not provide for an extension of any of the CARES Act coronavirus related distribution and loan rules beyond the end of 2020. So if you'll recall, one of the things the CARES Act did is allowed retirement plans to let people take a distribution of up to $100,000, even if they hadn't terminated employment from their plan, if they could show that they were adversely affected by coronavirus. It also expanded the availability of participant loans. That was set to expire at the end of 2020, and in fact did expire. We anticipated that the Act would extend it beyond it, but it did not do so. What it did do, however, is added another category of disasters for which these types of distributions and increased loan availability would be available. So through February 25th of 2021, similar distributions and loans are available to individuals affected by major disasters other than COVID-19. Really what this is targeted at is primarily the wildfires out west. So they wanted to provide an additional opportunity for folks that may have been impacted by those disasters to receive additional distributions and loans from a retirement plan. The Act also extended the ability for employers to reimburse employees for student loan repayments through a Code Section 127 educational assistance plan through December of 2025. That was originally designed to be a one-year rule that would have ended at the end of end of 2020, but they've extended that through 2025. What that would allow you to do is if you have an educational assistance plan, you could use that to reimburse your employees' student loan payments up to the annual limit of $5,250 per year. The other major, and Kathy, if you advance the slide, the other major set of changes have to do with expanded flexibility for flexible spending account plans, including both health flex plans and dependent care assistance plans. First, they extended the rules that would permit some additional flexibility in elections through 2021. Originally, by agency guidance, that relief was being provided through 2020. We've added that through 2021 as well. It also allows unlimited carryovers from 2020 to 2021 and from 2021 to 2022. So a plan may permit a participant who has a balance at the end of each of those years to roll that money over for use in the subsequent calendar year. Also allows for extended grace periods for up to 12 months. And also allows a individual who may have ceased participation in a flexible spending account plan, such as due to termination of employment during the year, to continue to submit reimbursements for expenses that were incurred through the end of that year. So if you get terminated mid-year, you could allow the employee to continue to receive reimbursements for expenses that are incurred up through the end of that calendar year. And finally, it liberalized the rules for a dependent care flexible spending account to allow the plan to reimburse childcare expenses for individuals with kids who are 13 and 14 years old. Under normal rules, those are limited to childcare expenses for children under 13. This is a temporary expansion of those rules to allow reimbursement of expenses in certain situations for children who are 13 and 14 years old. Important thing to note about the FSA changes is these are entirely optional. A health flexible spending account plan or a dependent care assistance plan does not need to implement these changes. It is up to the employer if it wants to make these available or if it wants to set limitations on any of these new rules. If you want to implement them, amendments will be required. While you can implement them in advance of adopting an amendment, eventually you will need to adopt an amendment to reflect the rules that you adopt. For rules that are applied in 2020, you generally have until the end of 21, and for rules that will apply in 21, you would have until the end of 2022 to adopt the appropriate amendments. Again, we'll be doing another webinar that will go into these rules in greater detail, so stay tuned for that if that's something of interest to you. Pete, back to you.
Hey, Aaron, real quick, is the date set on that yet, or are we still working on the date?
Yes, it is January 27th, Wednesday, the 27th at noon.
All right, and we'll send out something on that.
Yep, it'll be going out today.
Second thing is, these things are options, right? I mean, people can pursue if they think it would help. Is that how it works?
Yeah, that's correct. Yeah, all of these changes are optional. Employers do not have to make them available. And there are lots of good reasons perhaps not to make them available. It adds a great deal of administrative complexity to your flexible spending account plans. But for employers who want to give their employees that additional flexibility, these rules are all available. But you can pick and choose which ones you want. They're not, you don't have to take them all. You can do one rule and not the others.
Great. Okay, thank you. All right, we're going to wrap up today with Laura Harshbarger. Laura's going to talk a little bit about, I think we're going to do a series of these things, and today we're going to talk a little bit about how you may save a little bit of resources, keeping in mind your compensation, personnel costs, things of that nature. Laura, take it away.
Thanks, Pete. So one of the very unsurprising effects of the pandemic is the need for many businesses to find cost savings. Almost universally across all industries, the highest expense of a business is personnel costs. So compensation and benefits. It's often said, it's generally true that personnel costs are the overwhelming majority, right, of any business's expense. So very often we are called upon to answer questions about employers' ability to attempt to control those costs, and in particular to reduce compensation. Not something that a lot of us like to think about. It obviously has some significant morale implications that everyone would clearly want to consider before ultimately going down this route. But we'll just answer the general question: is it possible to reduce employees' compensation? We need to think about this in probably three different distinct buckets. One would be a non-unionized workforce. One would be a unionized workforce. And then the third would be employees who are under contract. So let's assume that we are talking about businesses, private employers who are non-unionized. In that setting, and again, assuming that employees are not under contract, individual contract, the rule is that employment is at will. That's the general rule. So this means a number of things. One of the things that it means is that employee's compensation is not a contractual guarantee. So the employee does not have a contractual right to a particular salary or a particular hourly rate. So an employer considering reducing compensation is going to consider a number of things. One would be, was this going to be something that is looked at across the board, and across the board 10% decrease, let's say? Is this a measure where an employer might go by almost kind of gradation, right? So perhaps the highest level employees, the most highly compensated employees, perhaps they would see a reduction in their pay, but not lower paid employees. A permissible way to approach such a thing. Or maybe it's that the highest paid employees have the highest amount of reduction, lower employees a lower rate of reduction. There are many different ways to approach it. Other employers might say, I know I have a particular but yet a large segment of my workforce that is paid more than market, and those are the employees that I need to address, in terms of their compensation. So what do we need to keep in mind if this is potentially on the table for your business? First, obviously, would be minimum wage requirements. So if you have hourly employees, we need to keep in mind what the 2021 minimum wage rate is in New York. In New York City, Long Island, Westchester, it's $15 per hour. The remainder of New York State, it's $12.50 per hour. So clearly could not dip below those levels. When we're talking about exempt employees, we obviously have different minimum weekly salaries in order to maintain the exemption. New York City, it's $1,125 per week. In Westchester, Suffolk, and Nassau counties, $1,050 per week. And the remainder of New York State, $937.50 per week. So if you're thinking about reducing an exempt employee's salary, have to keep those minimums in mind if you want to maintain those employees as exempt. The consequence of bringing the salary below the exempt level would be that now they have become eligible for overtime. So you have to perhaps do some trade-off analysis of which is better for the business and better for operations. Will a reduction in salary cause it itself cause a loss of the exemption for employees? And we often get this question, as we all know, right? What's the hallmark of an exempt employee? Well, they're paid the same salary every single week, no matter how much, whether it's not based on their production, it's not based on their hours. As long as they work any time during the week, they're due their salary. So is it permissible? Do I lose the exemption when I reduce that salary? The general rule is that this can be done. It needs to be done in a certain way, but that it can be done. The hallmark of the proper way to go about this is that a reduction in an exempt salaried worker's salary must be intended for the long term. It cannot fluctuate on a week-to-week basis, a month-to-month basis. Well, this week, we had about 20% less need for our exempt employee, and therefore we're paying that person 20% less. Cannot work that way. If an employer, based on financial considerations, market considerations, other considerations, determines that on a long-term, basically, semi-permanent basis, that this employee's salary should be adjusted downward, that alone will not cause the loss of the exemption. Now, if your workplace includes unionized workers, it goes without saying that reduction in compensation would be subject to mandatory bargaining obligations. Most folks are going to find themselves either coming up on the end of a contract or in the middle of a contract. In the middle of a contract, unless the union agrees to a salary reduction, then you're going to find yourself paying what you're obligated to pay in the collective bargaining agreement. And then when it comes to employees with individual contracts, again, somewhat goes without saying, you need to look to those individual contracts to determine what your rights are as an employer. If you find yourself in need of a salary reduction, you may attempt to renegotiate with an employee. We sometimes get the question, what happens if I have provided the employee with a letter with his or her evaluation at the end of 2020 that has said your annual salary for 2021 will be X? Does that mean I can't change it? And the general rule is no. I mean, we obviously want to look at an offer letter and wherever this language is appearing. But the general rule is that the fact that you have stated the employee's compensation in terms of an annual salary does not change the employee's at-will status and would not alone be a barrier to making these changes. Please recall that if there is going to be a decrease in compensation, and you've kind of touched all these bases and otherwise set to proceed, you will need to provide new Wage Theft Protection Act notices to those affected employees. And those notices need to be provided at least one payroll cycle before the reduction is to take effect. You will recall that you don't need to provide new Wage Theft Protection Act notices when you increase an employee's compensation, so long as that increase is being reflected in the pay stub. But when you decrease, you actually have to provide a new Wage Theft Protection Act notice. And again, it has to be advance written notice prior to the time the employee starts working at the lower rate. So there are many, many nuances and many facts that any employer would want to take into account before deciding to proceed with salary reductions and how to implement those reductions. But this is at least kind of food for thought to perhaps get you started if you're finding the need for some personnel cost savings in 2021.
Thank you, Laura, and thank you everyone for being with us today. We appreciate you spending a little time with us each Tuesday. We'll be back here again next Tuesday at noon. In the interim, please stay safe.